So here we are for real. Amy Howe of SCOTUSblog. She's already been introduced. I hope you found that first part useful. And now's your opportunity to ask all of the questions.
Exactly.
All of your specific
shorter,
questions.
right?
And Amy, I'm actually going to start with the question that came in online,
Okay.
but I didn't ask it because we were out of time and it was not really pertinent to that discussion.
Okay.
Should Justice Ginsburg resign?
No.
That's the question.
I don't think she should. You know, she is Justice. I mean, Justice Stevens was there until he was 90.
Right.
She's only 81. I mean, so she is a youth.
She's a baby.
By Supreme Court standards.
I have a question actually about SCOTUSblog.
Okay.
How is it that SCOTUSblog is still like the only game in town when it comes to breaking news coverage of the court? And does your credentialing, or I guess lack thereof, does it affect how you're going to cover the court this term?
It does not. I'll start with the second question first. It does not. I mean, Lyle Denniston is our primary reporter at the court, and he has been covering the Supreme Court for 55 years now. He has it's something ridiculous. Like, he's covered 1/4 of all of the justices who have ever served. And so he has right now, they're reviewing their credentialing process at the Supreme Court, but he has right now a credential, and has always had a credential through WBUR in Boston. Most of the credentialing action has been, for those of you, I won't bore you with all of the details, but if you haven't been following it, most of the credentialing kerfluffle was over at the Senate. He had a credential through SCOTUSblog at the Senate for a year, and then they revoked it. But he's always had, for the entire time he's worked with us, a credential through WBUR in Boston, and so he, he has what's known as a hard pass, and he can go. He's got a desk in the press room. They have been very accommodating for me. I was a practicing lawyer until a couple of years ago, and have switched over to full-time blogging. And since I switched over to full-time blogging, I no longer use there's a section of seats in the Supreme Court that are reserved for lawyers. The catch is that if it's a big case, with same-sex marriage the first time around, we had line standers who got in line at 1 o'clock in the morning, and I still didn't get for one of them a seat in the courtroom.
When you say you had lines, you mean you personally hired people, or you're saying there were people?
No, we personally hired people. And this was very controversial. I don't know if they're going to let us do it
like homeless people
this time around.
Like,
yeah, I mean, we hired them through the service that my husband's law firm uses to file Washington Express. They have line standers, but I think they are usually people who are down on their luck, who make $15 an hour or something like that to stand outside. It was very controversial at the time. I have this term, and at the end of last term, have had seats in the public section of the Supreme Court that were reserved for me by the press office. And so I was actually just behind just in front of the Citizens United protesters 2 weeks ago. Yeah, but the back of my head is in their video. So that's I think the second part of your question. The first one was,
how is it that no one else, like
no,
Politico or the Times, why is it the SCOTUSblog is the one that does this breaking news coverage?
I think some of it is just that once one person is doing it, nobody else feels like it makes sense to do it. The other thing is that it's expensive. To have a full-time reporter, 2 full-time reporters in essence, because I'm a full-time editor and reporter. We have a blog manager, and then to pay someone to hunt down all of these briefs that aren't available online. The court is switching over to electronic filing eventually, but for all of the briefs that get filed before the court decides to grant cert, she has to. We have a law student out in Washington State who hunts all of those down and posts them online. So I think it's just a finance thing. Yes.
How do you keep track of cases as they move through the court system? I keep track of them by going to SCOTUSblog.
Right.
So how do you keep tabs on all the things that are bubbling around?
This is kind of a resource thing. I mean, my former law partner, my husband, and the publisher of the blog, one of the things that he does is he gets a list of all of the petitions from, I think, Westlaw, all of the petitions for certiorari that have been filed, and he looks at the question presented and who filed it, and makes a quick judgment about whether or not it's something that he thinks the blog should file, and then hands it off to Mo, our law student in Washington State, and she creates a page on the website for that particular case and tracks down the briefs, and then it's set up so that every time we have macros that scrape the court's docket. Every time something happens on that particular electronic docket at the Supreme Court, it gets updated in essence, and so it's just a question really of throwing resources at it. Yes?
Do you have folks in all 50 states? So like you're saying you have someone in...
Oh no, we have a law student. If you go to the website, we have pages for each of the cases that are argued on the merits, and then the ones that we think are worth following before they get to the merit stage. And so we have one law student who, that's her job, 15 or 20 hours a week, and we pay her to track down these briefs.
So you start when they are actually petitioned?
Yes.
Okay.
Yes. And every once in a while we don't track what I call the prisoner cases, the more broadly what are informa pauperis, the ones that get filed that just statistically have a much smaller chance of being granted. And so there are, not infrequently there are cases that get granted that we haven't been tracking because we just don't have the resources to track all of those. They're often not filed. There are often no electronic copies if it's a prisoner or something like that.
How does she track down the briefs? Does she call the filer of the brief?
We have a couple different ways. Sometimes she sometimes she calls. There are only usually three or four printing companies that print these briefs. They have to be printed in this cute little they look like booklets. So sometimes she gets the briefs from the printers. She has a relationship with Paul Clement's assistant. Can I get this brief that you guys filed last week? And sometimes people send them to us because they want us to pay attention to them. I mean, I'll get emails every once in a while from somebody who's a friend of mine. It's like, my clients want to know why we haven't been the petition of the day yet, kind of a thing. So,
do you ever
people
track things like? I'm thinking in particular of the cell phone search cases because
Yes.
I covered a lot of them at the appellate level, and it was pretty clear that those were going to bubble up. Or the gay marriage cases when they start to sort of come out different ways. Do you guys pay attention to that, or is it just informally that you're keeping it?
It depends on the issue. Lyle Denniston covers the same-sex marriage, has covered the same-sex marriage issue pretty exhaustively since the last go-round 2 years ago. And so, every time a ban got struck down somewhere, he would cover it. He's got a real interest in the detainee cases, so he covers a lot of those. But otherwise, it's usually more sort of informal. We just don't have, we don't have the resources to do all of that in the back.
When you talk about how many inmates file cases,
Yes.
the majority of them aren't seen. This recent case in Arkansas with the beard,
Yes, and see, but sometimes they do.
Right. So, my question is would that be an example of one of those cases that actually does end up garnering attention and making things change versus in a sea of other claims by inmates that don't usually get heard?
It's an interesting question. I think that by the time his case, I think he may have filed his case originally by himself. Certainly, every single case gets, I feel pretty confident that, if you actually have a case that might be worthy of Supreme Court review and you file it as, handwritten as a prisoner, they're going to pay attention to it. And I think there's just a sense, particularly, and this is a little bit tangential, but over the last 20 years or so, the practicing at the Supreme Court has been increasingly dominated by a smaller group of lawyers. Joan Biskupik of Reuters did a really great study on it that came out a couple of months ago. And so I think that has actually, and so what happens is that a lot of these cases are, something like Holt versus Hobbs, the prison beard case, and the decisions come out, in the Court of Appeals, and a lot of law firms are actually out, including my husband's law firm, are actually out sort of looking for potential Supreme Court cases. They look for things in the lower court's decision that's going to tag it as a possible Supreme Court case. And so I think that actually adds to the sense of if it's a case that's worthy of our attention, some law firms are going to have found it and will file, a nice petition, because people do believe that if you file as a bound petition, you're going to get more attention than if you file as a pauper.
Can I ask one more quick
Yeah.
question? So, at my news organization, we recently kind of suddenly lost our Supreme Court reporter, off-air reporter, who will soon have replaced, but just in the interim, we've all been asked to watch out on news, which is, for people who don't cover that every day, kind of a difficult task, even if it's a crowdsourced request. Other than SCOTUSblog, which has actually been like the only way we've, in the most recent decisions that have come out, we've gotten that news. Do you have any other suggestions?
The Supreme Court reporters are pretty active on Twitter. So that's another good place to watch. There's Bloomberg BNA has a reporter named Kimberly Robinson who's particularly active on Twitter. But Greg Storr, also of Bloomberg News, Mark Sherman of the AP, Adam Liptak. For Adam, I think his first priority is probably filing his story rather than tweeting. But some of those folks are usually pretty quick on Twitter, and it's a good place to just get a sense of what's going on at the court quickly. You're also lucky in the sense that the court is now in its recess, until the end of February. So there's nothing coming out of the court anytime soon. Yes.
So I think besides the efforts, I think SCOTUSblog has really shown people how to start a blog. And I think I'd be interested to see or to hear when you guys were first starting this thing up at O2. Yeah, when you guys first.
Yes, very good.
First starting this thing up at O2. Did you guys think it would be as big as it was? Like, what was you all's biggest year? And how did you get the word out there about it?
Right. It's a good question. We actually started, and that's actually part of the talk that I usually give here. We actually started it. My husband and I were practicing law together in 2002, and it was just the two of us. Neither one of us clerked at this. We didn't have any of the background that you would expect of someone who would practice before the Supreme Court. We didn't clerk at the Supreme Court. We didn't go to fancy law schools. And so he came to me. There's another blog called Howe Appealing that covers appellate developments more generally. And he came to me and he said, I think we should start a blog that focuses on the Supreme Court. And I was 7 months pregnant, and we were doing a gut job renovation of our house. And I was like, that is a terrible idea. But his idea that it would originally be a business development. That would be sort of our one advantage, was that we could have this, if we were a boutique law firm focused on the Supreme Court, this would be how we would show off how much we knew about the Supreme Court. We, basically, if somebody sneezes at the court, we report on it. Was the idea, and it was an abysmal failure as a business development tool. But we had a lot of fun with it, and it sort of slowly grew. And then we had the chance to hire Lyle, who had 2 retirement parties at the court. So I hope I get invited to his 3rd one at some point. But he's not allowed to retire. So
and you're not making any announcements today.
No, definitely not. But so it sort of grew pretty steadily over the years, and then really peaked. I think the first big year was the year that the court decided a case called District of Columbia versus Heller, whether or not you have a Second Amendment right to have a gun in your home for self-defense purposes, because that's an issue that a lot of people feel very strongly about. And then we gained sort of steadily, but not massively, until 2012, which was the year of the individual mandate. That was our biggest year by far to date, and then we've sort of grown steadily. We've never had as many people on the website in one day as we had in 2012 for the day that they announced the decision.
It was several 100,000.
It was over 1 million. Yeah. But we, in terms of our annual page visits and site views, we've grown every year since then. And I think this could be our biggest year, because we've got both same-sex marriage and tax subsidy and ACA subsidies.
As a follow-up to that, is it now a money-making venture? Are you making money off of it?
No, we are back to not making money off of it anymore. We were sponsored for 3 years by Bloomberg Law, which they were incredibly generous, and then the 3-year contract ended last fall, and they decided they did not want to renew the relationship. So right now we are back to being funded by my husband's law firm, which does not help when you are trying to get credentials, but and hopeful that something else will come along soon.
So where does the bulk of your money, in terms of like what you spend on media, like where does the bulk of that money go? Does it go towards writing? Does it go towards front end, back end development? That's a real inside baseball.
Yeah, I mean, most of it goes towards salaries, and we were able with the Bloomberg deal to give Lyle a raise. It was sort of embarrassing what he was being paid before, just because we didn't have the money. We're still not paying him what he's actually worth, but and so that Lyle, Callie Borkowski, our blog manager, who's a recent college grad, and I are all sort of the bulk of the expenses. But then our development and sort of server maintenance can be incredibly expensive. I am not heavily involved with that, but the day that the court announced healthcare, and we spent like $25,000 to upgrade our servers to make sure we didn't crash, and we didn't, because we had in the days leading up to healthcare, one of the previous big opinion days, we'd had someone try to hack into the site, so we wanted to make sure that didn't happen. Yeah.
So when an opinion comes out, I know you guys have sort of a system, but for someone who hasn't argued cases for the Supreme Court, how do you read an opinion quickly and know that you've gotten it right and start getting something out there?
Yeah, I mean, that's a good question, because each of the justices also writes very differently, and so they have a really good syllabus at the front of the opinion, and that's usually where you start. I mean, you want to sort of read that there will be a section that says holding, and that's probably the most important thing that you can look at. There's usually, depending on the justice, also a nice paragraph somewhere, in the first quarter to third of the opinion that says, we reverse, and send this case back to the Fifth Circuit or something like that. And then you also want to look quickly if there are dissents to see what exactly it is that they're saying, to figure out. That's where everyone went for in Bush versus Gore, which was, I imagine, well before all of your times, but to figure out what was actually going on in the case, because it was so quickly written that it was hard to understand from the majority decision what was actually going on in terms of whether or not the vote was going to go on. I haven't called on you yet.
I think you guys are widely known as being extraordinarily fast, which is amazing. How do you, when a decision comes out, and I've been on the live blog, you sort of mentioned there's like a box and the decisions come in. How do you get the information out there so quickly? And have you ever had a situation, like CNN or whatever, where they just totally botched it because they were trying to go so quickly? And how do you do it so quickly? And how do you guard against getting it wrong?
Right. I mean, part of it is really it's sort of a two-part answer. I mean, for the average decision day, I mean, Lyle's been doing this for 54 years, and that's CNN and Fox. They had people who were smart, but nobody else has been covering the court for 54 years, and so he knows what to look for. He's covered the argument very thoroughly, and so he's able to do it quite quickly and quite accurately. For the really big cases, and healthcare was one of them, we often do things a little bit differently. We'll usually the way that we work is that Lyle is down at the court in the press room, and I'm back in my office in Bethesda, and I'm on the phone with him, and he comes on and tells me what's going on. For the big decision days, we may well be down at this or very close to the Supreme Court because we're not allowed in the press room, and we'll have sort of a committee that looks at the opinions, and that's what happened with healthcare, is that nothing went up on the blog until everybody agreed that this was the holding. So it's a luxury, yes.
Can you talk a little bit about how you got Lyle on board the SCOTUSblog?
Sure.
I forget how long he's been with y'all.
2004, I believe.
Wow. So
It's been. We were pretty new. Yeah, we were pretty new, and we were we were kind of dabbling before. I mean, we both had practices, and at that point we had one child, and so it was like if we thought something was interesting, we'd go cover it, or we'd find someone to cover it. But it certainly wasn't comprehensive coverage, and we were just lucky for the most part. We were sort of thinking about sort of ramping up our coverage, and he was going through his second retirement from the Boston Globe, and Tom said to him basically, "Do you want to come and work with us?" And he's 84 years old, but he really liked the idea of doing something totally different. And so he can, for the most part, I'm his editor, and so I, for the most part, do look at everything that he writes before it goes online. But I mean, certainly a lighter touch in terms of the editing, and also in terms of him having near total control over what he wants to cover. And so he was like, "Great, I'll do it." And that was now 11 years ago. So.
Wow. When you took Waiting for Lyle, I had this image of him like running down the hallway, but I didn't know he was 84 years old.
I think he still does run down.
So if he can't go in the press room, what does he do?
He is in the press room because he has one of those hard to passes that I was telling you about.
From where? From
WBUR in Boston.
Okay. And does he ever file anything for them?
Occasionally, I think.
Wink, wink.
What has been like coming to this from a legal background? What has been most beneficial about having a legal background, and what has been like the hardest thing on the journalism side of it?
Sure. I mean, I think coming to it from the legal background is that this was something I'd been doing for. Before I went full time, I'd been practicing before the court for, 10, 12 years.
Did you clerk?
I did not. No, I didn't clerk. I went to Georgetown. It was great, but I didn't have the sort of resume that most Supreme Court lawyers have. But I knew the ins and outs, and I knew everything about how the process works and what they're looking for, and sort of thinking, having been like the person who gets mooted at the oral argument, then I think you bring to it a better understanding of what's going on at oral argument and writing the opinions than somebody who comes to the court with a journalism background but not the legal background. I think that the hard side for me has been when you are a lawyer and you're writing briefs, that then you want to make sure you get everything right, and you want to get your prose perfect, and you don't have time to do that. And so that there's always a little bit, I feel like, of a leap of faith where you type something up and you try to make sure there are no obvious errors or typos, and then you hit publish and cross your fingers. So.
I have a question about the actual court. You mentioned the relatively few number of people who get to argue, private lawyers who get to argue before the court, and Paul Clement seems to be one of the few. And he's considered to be a better litigator than Donald Verrilli, and I wonder if that makes any difference in the decisions that come down from that. Or do you think he's better on his feet?
I don't think so. I mean, I think that Paul is often, and I think that they're both terrific lawyers, and this is not to take anything away from Paul, but I think Paul is often arguing, to preach, is more likely to be preaching to the choir. I mean, certainly he has arguments where they're not all, 5 of them or more going to be on his side, but I guess what I'm trying to say is I think Paul is a terrific lawyer. I don't think it's fair to Don to say that he's not as good, that he's just, often has a more skeptical audience in some cases, and he's also more constrained because he's representing, the entire U.S. government, and may have more constraints on what he can say than what Paul can say on behalf of a client. But they're both fabulous. I would take either of them any day.
On the business side, how's the search for a new sponsor going? If that's what you're doing.
It's still going. So I can't. I'm sorry, I can't say a lot about it. But hopefully we'll.
But if you know anyone.
Exactly.
Is that part of the tough? Like getting sponsors?
Yeah. I mean, we're not necessarily. It was so wonderful to have Bloomberg, who sort of funded all of our operations. We're not necessarily looking for someone who's going to fund all of them. But as you know, this is not a time to be asking news organizations for a lot of money.
Should start a podcast.
Yeah. So.
Something like that. What do you think of Justice Thomas and his sort of decision to not speak up from the bench.
Yes.
What's that about?
I'm not really sure what is going on there. I think he's got, he has talked in public about, he's given a couple of reasons. One of them is that he feels like this is the lawyer's time to argue. And then he's also talked about how I think that sometimes he can be self-conscious speaking. And whatever his reasons are, those are his reasons, and they're personal. I guess what I would say is that, as I talked about on the webinar, is that there's more going on in oral argument than just answering the justices' questions about the facts or the legal issues. That it's the justices' opportunities to talk to each other, and that he's essentially made a decision to sit that part of it out. Obviously, I don't know what's going on in the conferences, and certainly he speaks and they listen, but there you can see some of the justices. Justice Kagan is kind of a master of this. Justice Breyer does it as well. Really trying to use oral argument, to draw out points that she thinks are going to help the side that she wants to win, or to address her colleagues' concerns based on what they've said at oral argument. And obviously he doesn't do that.
It's more than just being quiet, though, isn't it? He seems very disengaged at times. I've been to a couple arguments where he's leaning back in his chair, looking at the ceiling. It just seems like he's not even paying attention. Jeffrey Toobin had a very scathing piece about this a few years ago, I think.
I do think that there's some there in this. I wouldn't say that I think he's disengaged. I would say that I think that he's probably after his confirmation hearing, I think he's very dubious about the press generally, and I think that the more that there are stories about how long it's been since he's asked a question or said something, the less inclined that makes him to ask a question.
So then does that mean necessarily that you believe that all the justices read what's written about them?
I wouldn't say they read everything, and I would actually guess that he reads very little, but I think probably enough. I don't know this, but I think that I think it a lot depends on the justice. I think some justices read a lot more about themselves than others do. So
how have the personnel changes on the court over the past, administration, in your opinion, how has covering the court or being in front of the court changed in that time?
I think it seemed hard to believe, but I think it's an even hotter bench now than it used to be. You think about these are the Justice Sotomayor and certainly Justice Stevens and Justice Souter ask questions, but Justice Sotomayor in particular asks a lot of questions. You can see that she was a trial judge. She's always very concerned about the facts of a case. So I think it's probably gotten you can expect to be asked even more questions. You expect to hear even more questions. I'm not sure whether that actually answers your question.
Do you know who's in the pipeline next to replace any of the sitting justices?
So much depends on who this is one of my favorite parlor games, but who retires and who the president is. I think I wouldn't be surprised, even though I don't think Justice Ginsburg should retire, but I think she's kind of now run out of time. I think that she, even if someone could be confirmed to replace her, I think she would probably feel like that person would not, President Obama would have to nominate someone who is not as liberal as she is to get that person confirmed. I think that if a Democrat is elected in 2016, I think that the Democrats having gone with the nuclear option created a whole bunch more opportunities to put people on the bench. Patty Millett of the D.C. District, Nina Pillard, and some of the other younger Court of Appeals judges who've been nominated and confirmed in the last 2 years or so would be likely candidates. I think a lot would depend on who resigned. If it were a woman and a Democratic president, I think that president would feel an overwhelming obligation to nominate another woman. If it were a man and it were a Democratic president, I think Sri Srinivasan, who's on the D.C. circuit right now, would be the first Indian American judge on the Supreme Court. Would probably be a front runner. He's still quite young. It gets tougher if it's a Republican president either way, just because Republicans tend to appoint their judges younger, and their justices as well, and there's been kind of a void for 8 years. I mean, the Democrats would have had the same problem to a certain extent at the beginning of the Obama administration, but they are willing to appoint justices and judges who are older. So that, to try and find somebody who's in his or her, if a Republican is elected, in his or her early 50s, who's sat on the Court of Appeals, there aren't a lot of those running around, just because it's been 8 years since the Republicans were in control of the White House.
Who's considered a young judge? How young is young?
Well, it depends. It depends on who's in the White House. I think Kagan was young. Kagan was 49 or 50, right around there when she was confirmed. Sotomayor was a little bit older, maybe 55. I think for Republicans, I think you're definitely looking more at early 50s at the latest.
Well, Roberts was pretty young.
Roberts just turned 60 this January 28th. I can't believe it.
Can I just clarify something you said about Ginsburg running out of time? So does that mean, when you say you think she's running out of time, that she will wait until the next administration, or she will go? Okay.
No, yes, that she needed to do that before the Senate changed hands, I think, from her perspective.
Could you talk about the Oklahoma executions
yes.
case that was brought up before the court?
Yes.
How is it different than other cases, meaning the Attorney General, I believe, was the one who filed
Yes. Okay, yes.
petition.
Everything about this case was weird. And so this was the case where 4 inmates on death row in Oklahoma filed a petition asking the Supreme Court to review their challenge to the lethal injection protocol in that state. And the weird thing was that back on January 15th, the first of those 4 inmates was scheduled to be executed. He went to the Supreme Court, asked them to stop the execution, and they declined. The 4, what we think of as the 4 more liberal justices, wrote one of these dissents saying, we would have stayed his execution. So he was executed. But then the weird thing was that the Supreme Court, 10 days later or so, granted review of the remaining 3 inmates' cases. And so there's this practice on the Supreme Court that has not been uniformly used, but has mostly been used, called the courtesy fifth. And the idea is if there are 4 votes to stay an execution, but not 5 votes, 4 votes to grant cert, but not 5 votes to stop it, because you need 5 votes to stop the execution, that a 5th justice will throw in his or her vote, so that you don't have this, and they had it happen a couple times in the 70s and 80s, this sort of unseemly event where they grant somebody's petition for review, but then it becomes moot because he's already dead. But that didn't happen, and so we're not really sure what's going on, whether or not the idea is just that they're willing to review this challenge to lethal injection in the abstract, but without regard to what it means for particular prisoners. And so then what happened was that Oklahoma itself, because the next inmate was scheduled to be executed on Thursday, so Oklahoma itself went to the court last Thursday and said, we want to stay these particular executions because right now we don't have any other way to execute them besides this lethal injection protocol that is now under review. But we wanted to leave out, they wanted to leave open, it was essentially preemptive. They wanted to leave open the possibility that they could still carry out the executions if they can use some other method. But that's harder than it seems, because most of these drugs come from Europe, and the European manufacturers won't send them to the U.S. to be used in executions. There's like, we're not helping you out here, folks. And so it's, that's been a sort of another, which was why they were using this particular drug in the first place. And so it followed an execution in Oklahoma last year in which the inmate, as Justice Sotomayor related in her dissent on January 15th, was writhing on the table in agony and saying, it's not working, long after he was supposed to be unconscious. And so they're going to take up this challenge. They had another challenge to Kentucky's lethal injection protocol back in 2008 and upheld it. And so we're all kind of curious to see what's going on here. Are they just concerned about this particular drug? Are they going to revisit lethal injection more broadly now that we know a little bit more about it? But nobody's really sure.
There's none of because some of the states that are dealing with this, there's a lot of transparency issues at play. Like you described, that Europe doesn't want to send us the drugs, and there's like going across state lines and playing for cash. But none of that is at play in the Oklahoma.
That's right. That's right. I mean, yes. So my husband's firm had one of these transparency. They had somebody in Louisiana, I think, and Adam actually wrote about it, where he said, I want to know, I have a right to know how you're going to execute me. The state was like, yeah, it's going to be fine, trust us. And the Supreme Court didn't review that case. The state eventually agreed to stay the execution.
Missouri has claimed privilege over.
Yeah. And so, I mean, there's all kinds of issues. The physicians are not allowed to participate in the executions, at their Hippocratic oath, and so it's kind of a mess. And so everyone's interested to see how much of a mess is the Supreme Court going to actually straighten out here? Are they going to do a lot or just a little? They've let a couple of executions go forward recently, so it's not clear. Yes.
Has that been a problem for SCOTUSblog, having your husband's firm? Does he represent, you guys write about cases, or his firm is representing someone for the firm?
We do not. I mean, it's definitely a credentialing problem. We have put in place to address the sort of objectivity issues a fair number of firewalls. Until probably 2 years ago, Lyle would still report on his cases, but with the disclosure that he operates independently of the law firms. And if you read some of the coverage of his oral arguments by Lyle often was quite critical. It's like, I can't believe he made the curious choice to do such and such. Lyle no longer covers any of the firm's cases, so we've sort of taken that out. I mean, we do report on them. We find someone who's got no affiliation with the firm. It hasn't been a huge problem in the sense that he hasn't been involved in some of these super high profile cases, healthcare, same-sex marriage. So Lyle hasn't had to choose. There've been a couple of cases. His partner was involved in one of the cell phone search cases last term because he was teaching at Stanford, and Jeff Fisher, who's the law professor at Stanford, was the lead in Riley versus California, the case out of California. And so Kevin dropped out of the case so that Lyle could cover it. But, it's certainly, I think, as far as the credentialing goes, an optical problem. And, we try to disclose any involvement of the firm whenever it comes up, either on the case page if somebody's writing about the case, but it is what it is. I mean, without the law firm, we wouldn't exist, and so it's kind of a catch-22.
What could you tell us about the dynamic among the justices? These people are so shielded from the public eye, but you get to see them a lot more than we do. Like, how do they interact with each other? Any quirks, like personality traits that we wouldn't know about from just reading an article? Yeah, I mean, they are, sort of some very different people. They all are. They have a lot in common in the sense that they all went to very good schools and were very successful before coming to the court. Some of them socialize quite a bit outside of the court. Justice Ginsburg and Justice Scalia, always attend the same New Year's Eve party. Justice Kagan and Justice Scalia have gone, go shooting and hunting together. And so I think it varies by justice. Justice Thomas is fascinating to me. I've never met him in person, but if you ask me, like, which justice would I like to spend an hour with, he would be at the top of my list. He's got this sort of reputation as being sort of disengaged and quiet on the bench, but he's an incredibly gregarious person, apparently, outside of the courtroom. He's the one who knows every single person who works at the court. He and his wife travel around the country in their RV, and will camp out at Walmart parking lots, which I guess they make the facilities available for RVs. And people have no idea who they are. He's loves college football. Justice Ginsburg is really into opera. She spends part of her summer in Santa Fe at the Opera Festival every year. Justice Breyer he's kind of the sort of very smart but somewhat absent-minded professor who asks these incredibly long hypothetical questions, and you really always, like, when you're listening, you feel really sorry for the lawyer who's going to have to answer it because it's all you can do to keep track of what the question was.
Do you ever see an instance where the government is defending, you know, a position that they don't, like the administration doesn't want to defend, and how do the lawyers sort of, I mean, do they throw the case, you know, in their briefs kind of thing?
It's an interesting question because sometimes, and this has actually happened in the first case that I argued, sometimes the government will actually get to the Supreme Court, and it's particularly likely to happen actually in criminal cases, and change sides. And so I won't bore you with the details of the case, but they had argued, you know, below that my client was wrong and they were right, and then it got to the Supreme Court, and they agreed with us that the Supreme Court should take the case and switch sides. And so what happens in that case actually is that the government gets to argue. The government, you know, it splits a half an hour and a half an hour on each side. The government got 15 minutes of my argument time to make the same argument that I was making, and then the court appoints someone to argue. It's known as an amicus or an amicus, depending on how you want to pronounce it. An amicus in support of the judgment below. And so usually it's some youngish lawyer who hasn't had a chance to argue before the court, usually somebody who clerked at the court. And, you know, this person gets to make the arguments about why the judges below were right and my client and the government are wrong.
Do you ever see, and we talked a little bit with Adam about, like, most of the time a lawyer can't win or lose a case in oral arguments anyway, but, I mean, would the government ever not ask to switch sides and just, like, half-heartedly do their part, or if they want to see something go their way, they would actually switch sides? Yeah,
they would actually switch sides. All of the lawyers for the federal government are really good, and they go through these really extensive moot courts, because in a couple of these cases I was on the same side as the government. I got to sit in on them, and so part of it too was that they wouldn't want to sort of compromise their credibility with the justices by doing something sort of half-heartedly or not sort of giving it their all. They would much rather switch sides. Sometimes it gets them into trouble, with justices. Not so much in a criminal case, but there was a case that I covered recently. And the sense was like, well, when there's a switch in the government's position from one administration to the other, and you're arguing that the court should essentially defer to the administrative agency, and there will be questions from the justices about, well, is this something that that is essentially political rather than some sort of considered legal judgment? And that, and some justices, Justice Scalia is one of them, is much more likely to look skeptically on if he thinks that the government has changed sides, to follow the political winds. And in a criminal case, they would probably just go along with whatever it is the government's telling them. Sometimes the government loses, though, too. Yeah.
So she sees me standing vulture-like.
Ooh, we have new mugs.
We have new mugs, yes. I'll present you with this one from the Evelyn Y. Davis Studios, where we just were.
Thank you.
So thank you so much. It's always fascinating to have you here. We really appreciate it.
Fun. Good questions. Thank you. Yeah.